We're so pleased that we've had so many people in the participant list. I'm just going to give a few more minutes for people to filter in, so we might start around 12:01 or 12:02. And like Nerida said in the chat, all attendees are automatically muted and off camera. And just to let everybody know, we are recording this session, and the recording will be hosted on our website afterwards. Hi, everyone. Thank you so much for joining us today. My name is Neha Shizad Chandarajan from the Canadian Centre for Women's Empowerment. We are so pleased to be able to host this webinar for you that is going to launch our National Scorecard on Economic Abuse. I'm joined today by Dr. Natalie Snow, who's our Director of Education and Research. We'd like to acknowledge that this project was funded by Women and Gender Equality Canada. I'm just going to acknowledge the land that we are on today. If you could go to the next slide, Natalie. We recognize that the Canadian Centre for Women's Empowerment is located on the unceded and unsurrendered territory of the Algonquin Anishinaabe Nation. For thousands of years, the Indigenous peoples inhabited and cared for this land and continue to do so today. We are grateful to have this opportunity to work on this land, and by doing so, we give our respect to its first inhabitants. Also, we'd like to honor National Truth and Reconciliation Day that is coming up on October 2nd. We encourage and challenge everybody to learn more about their traditional ancestral lands.
So it's September 30th, the day, but the holiday would be the 2nd.
Yes, thank you. Yeah, thank you, Natalie. Can we go to the next slide? I'm just going to go over a couple of housekeeping rules. Thank you. So because we are in the webinar format on Zoom, I'd just like to let everybody know that we are recording this session. The recording will then be hosted on our website and be sent out to participants later. If you could please keep yourself muted during the presentation, that's great. You should already be automatically muted. Please feel free to use the chat to ask questions or write any comments throughout. And if you have any concerns or comments, please put them in the chat as well. During the Q&A session, you can either raise your virtual hand and we'll provide you with microphone and camera access, or you can use the Q&A function or the chat to ask any questions. Please also follow us on X, Facebook, Instagram, and LinkedIn. Sorry, Twitter and X. the confusion just now. We are at CCFWE, and our hashtags for today are hashtag economic abuse scorecard and hashtag economic abuse. For if you have any comments or anything like that, we would love to hear from you on all of our socials channels. So please tweet and post about it on your channels. I'd just like to give a little bit of an opening. So for people who don't know what economic abuse is, it's a form of domestic abuse where a perpetrator tries to control someone else's economic resources or financial freedoms. It's a term that's usually used to describe the denial or restricting access to money or misusing another person's financial resources, but also restricting access to essential resources like food or clothing or transport, or their access to education, employment, or training. And this type of abuse has very devastating effects and long-lasting effects for its survivors and victims. It's experienced this type of abuse is experienced within 95 to 99% of domestic violence survivors and victims. But in Canada, it's something that's rarely spoken about. And that's why the Canadian Centre for Women's Empowerment, we want to bring more light to this issue. We're a national nonprofit that's based out of Ottawa, and tries to enhance the awareness and education of economic abuse through community-driven research, education, policy advocacy, and system change. Now, just to go over the schedule of events today, to shed light on economic abuse, we are launching this National Economic Abuse Scorecard, which Dr. Natalie Snow will be taking us through today. But we're going to go through a presentation of the scorecard, the methodology, and then we're going to introduce our panelists, our esteemed panelists who are here today, and we'll launch into a bit of a question and answer period. So with that, I will turn it over to Dr. Natalie Snow.
Hi, everyone. Welcome. I also just want to acknowledge I'm on the lands of the Mississaugas of the Credit and Haudenosaunee and Wyandot people. So I'm based out of Hamilton, Ontario. So first, I'll talk a bit about the objective of the economic abuse scorecard. So it's to illustrate the legislative response to economic abuse on individuals and communities. So the provincial territorial scorecard on economic abuse explores the current laws and policies by identifying model policies and adverse policies that create barriers for survivors. With the work on the National Action Plan to End Gender-Based Violence, this tool can be used to support the framework for action within and across jurisdictions with the goal of supporting victims, survivors, and their families. By pinpointing discrepancies or gaps, we can more effectively tackle this issue. The scorecard has several key purposes. The first one is the identification of gaps. This scorecard helps identify gaps in the legal and government response to economic abuse. It can be used as an advocacy tool. The scorecard can be used as this tool by activist organizations and community groups to raise awareness about the importance of addressing economic abuse and pushing for reforms. Number 3, enhancing the support for victims. Improving provincial territorial legislation and policy can lead to better support and protection for victims of economic abuse. Stronger legal protections may provide victims with the means to seek help and access resources to escape abusive situations. And finally, data collection and progress monitoring. So this scorecard collected data on provincial territorial legislation, exploring avenues for continued advocacy to support survivors. The data collection also allows CCFWE to begin tracking changes over time to legislation and to see how advocacy has really, if it pays off or how it pays off. So for the methodology of the scorecard, we use 2 main contributors, model policies and adverse policies. Model policies are when a policy positively supports the survivor, improving their lives and supports their healing journey. Adverse policy creates barriers in their attempt to break away from the violence and move forward in their healing. So we've identified 7 categories in each, 7 categories for and adverse elements of the policy. For every model, for every category, a model element is a point added. So 1 point for every and is added, and then for every adverse, a point is subtracted. The full table and scoring is available on our website, and we are going to go through it. The link will be in the chat as well. So for the categories, what we've explored here is the first question asks, does the legislative definition include economic abuse? Number 2 is, are work and leave policies inclusive of the complexities of intimate partner violence and economic abuse? Do the policies include litigation abuse protection? Are there designated intimate partner violence torts within the province or territorial legislation? Is the victims of crime compensation inclusive of economic abuse? And the process for rental protections for survivors, is it inclusive and supports when people fleeing violent homes? And lastly, are there alternatives to law enforcement that are funded by the government outside of shelters and women's organizations? So what I would like to note, though, is these categories are based on provincial territorial legislation. There are other elements in ways to support victims of economic abuse, but they are covered in federal policy, for example, banking policies. So that will be phase 2 of our project. So this one, we really focused on provincial and territorial. So here are the point values represented in percentages. As noted, through our table here, or our map, is that nobody scores over 50%. We've taken the point value and represented it as a percentage for easier comprehension, meaning that, so with nobody scoring even remotely close, well, to 50%, this means that our current policies are not as inclusive or supportive for survivors as it relates to economic abuse. Here is the table breaking down each province and territory by category. The ideal column over here on the left is the maximum score based on the model policies that we've identified through research and our own research and also empirical research, other studies. And then, so what we see here under each of the provinces is the total for each of the categories. And then we've identified, so we have the total in points, and then we also noted the variance in the scores, and then the score as a percentage is at the bottom. So that's what we saw in the map there. So some of the highlights of the analysis that we've done, many of the provinces and territories do show promise within work and leave policies, although it should be noted that the average eligible weeks of unpaid leave is 10.25 weeks, and the average number of weeks of employment needed to qualify for any of these to utilize this leave is 9.2 weeks, and the average paid leave is only 4.6 days in a calendar year. Also another promising thing is all but Ontario include economic or financial abuse in their legislative definitions, not decisions. The scorecard identified a number of gaps. First, there's limited options outside of shelters and women's organizations in alternatives to law enforcement as a response. There are limited litigation abuse protections with only Alberta and British Columbia that have legislative protections. For criminal compensation, many provinces and territories have strict parameters. So, for example, surrounding the availability and use of funds. For example, property damage is not covered, or personal safety mechanisms, such as changing the locks would be one example. They are not covered. Also, the province of Ontario no longer has a criminal compensation board. And although the province, they do have support through the Victim Quick Response Program, but that serves immediate needs at the time of the offense, but there is no compensation system available. That is a very brief overview of our map, of our scorecard. The scorecard is available online to where you can look at the detailed definitions and the detailed model policies and adverse policies within our legislation. or within our scorecard. So that's it for me. Thank you.
Thanks so much, Natalie. I just want to also acknowledge our funders, Women in Gender Equality Canada, who funded this project. And we'd also like to acknowledge the University of Ottawa's student law program called Pro Bono Law Students, who helped set up the scorecard, or the foundations of the scorecard. But I would like to introduce our amazing panelists. So we have Samantha Davis, who has her Master's of Social Work from the University of Victoria and has an Honors Bachelor of Arts from the University of Toronto in Criminology. She is the virtual legal advocate at Rise Women's Legal Centre, where she works with clients around British Columbia who need help with their family law matters. Samantha is passionate about creating access to justice and ending violence against women, trans, and gender diverse folks, especially at the intersection of family law. Naomi Sayers, who's with us today, she's a lawyer and an Indigenous feminist, and she was called to the Ontario and Alberta bars with nearly a decade of consulting experience. She has appeared at all levels of court in Ontario, along with federal court and the Alberta Court of Queen's Bench. Naomi represented WorkSafe TwerkSafe, which was the first and only federally incorporated nonprofit group that was dedicated to strippers' rights to work safely in Canada. And because of her advocacy work on behalf of this organization, it resulted in a precedent-setting decision, resulting in the court recognizing the harms that sex workers experience in trying to access justice. Naomi is also a member of the Women in Canadian Criminal Defense, Criminal Lawyers Association and its Indigenous Committee, Canadian Bar Association and its Aboriginal Law Section Executive, the Law and Mental Health Disorder Association, and many, many other associations as well. So we would love, I'd like to welcome both of our panelists here today. Thank you so much, Naomi and Samantha, for being here. Okay, good. Oh, I can see both of you. Amazing. So just to start off, I'd like to ask both of you, what stands out to you most about the scorecard results, just right off the bat, off the top of your mind? Maybe I'll start with Naomi.
Thanks. So what pops out at the top of my mind is sort of the obviously the gaps, the continued gaps that the legal system creates. This the criminal civil system. It can get confusing for victims of economic abuse and any sort of abuse. And then it's creating a lot of gaps in enforcement and compliance from policing perspectives. So you have policing agencies who are like, this is a civil matter, take it up with your bank, or there's not much we can do. When I don't agree with that, obviously. And it obviously leaves victims, feeling unheard, feeling not valued, and then the courts are then left to deal with the economic abuse themselves. And the courts, just as the Ontario Court of Appeal reversed the decision on the tort of intimate partner violence. So it's saying, to victims to go back and to look at what's already there, but I don't agree with it. But from a standpoint, I guess, from lawyers and advocates, we just have to get creative about finding solutions.
Thanks so much.
Yeah, I think I was the most surprised, honestly, as someone who lives in British Columbia, to see that BC scored a 4 out of 5 for litigation abuse protections. I definitely feel like, based on the number of clients that I have that are facing litigation abuse that's going completely unnoticed and unaddressed by the courts, I'm genuinely quite surprised to see that BC scored so high. And I wonder, I'm curious to take more of a look at the policies that you were able to find, and as part of this research, to see what's written down and how it's actually being used in practice, because I'm not sure how effective it is. I have a lot of clients where the litigation abuse that they're facing is so subtle that often they don't even realize what's happening, and we have to bring a lot of language to it as part of the work that we're doing together. I think I was also surprised to see how Ontario was the only province or territory that did not have an adequate definition. Yeah, that's what I would say for that bit.
Thanks so much, Samantha. And yes, thank you for the comments. Something we hope to improve upon for next iterations of the scorecard, if we manage to get to that, is having more interviews with lawyers like yourselves to be able to draw out sort of that qualitative element that can't always be seen by quantitative assessments. So thank you, that's fantastic. So Samantha, I'm wondering on your end, how can institutions improve upon these rankings in the context of family law? I know you're talking a little bit about BC and how they're ranked really highly, but in your experience, in terms of, clients that are going unnoticed, maybe you can speak a little bit more to that and how we can improve upon that.
Yeah, I think I won't use specific examples just to ensure that, anonymity is paramount, but I have had situations where clients, for example, will have opposing parties that will file hundreds of applications in court, and it will take hundreds of applications before they're deemed a vexatious litigant. Which again, it shouldn't have to get to that point. I've got other clients where the opposing party will file in one level of court, they'll get they'll have an order put in place that prevents them from filing more applications in that level of court, so then they'll go to the next level of court, and then once they've satisfied the requirements to be able to apply in the lower level, they'll go back there and apply more, even if they're doing the same things between the two levels of court. So for example, applying for let's say even something you can't do in one level of court, they'll do it in both, just to slow things down, have our client have to respond to the application, those sorts of things. But because the different levels of court aren't necessarily communicating with each other, and that sort of like level of, I guess, awareness between what's happening in the two different files, there's no, it's harder to show kind of the process of what's happening. I think generally too, I know that my question specifically is about family law, but I think that bringing more awareness in the court system around how much like housing instability and those sorts of things are impacting our clients every day, and bringing that into making decisions about the clients' issues that are going on, right? So, for example, one of the questions is rental protections for clients. That's obviously so important in ensuring that when, let's say, a relationship ends, that there's rental protection for the survivor, the victim. But also, where does that client go, and what sort of protections, or I guess like not advantages, but sort of measures are in place to ensure that they actually have stable housing to go to. That is a huge concern in BC right now. I have so many clients that are on the brink of homelessness. I have a client that has to leave Canada because she can't stay here, because there's nowhere for her to be able to afford to rent, and her EI has run out. So those sorts of things being taken into account. I have no idea how that would happen institutionally within family law necessarily. Obviously, that's a bigger systemic issue in the province, but it's definitely something that I hope would be addressed, even if it was moving family law files along faster in some way. I know there's a lot of measures in place in BC that are trying to do that, with family management conferences and judicial case conferences, where they try and sort out as much as possible in a conference setting. But the housing instability and risk is such a huge factor. And so much of the time, clients can't focus on the rest of their family law matter because their housing is so unstable that it's just not a priority. Yeah.
Thank you, Samantha. Yeah, that's a really comprehensive description. And it's something we hear so much, especially with the housing instability factors. You know, your shelter is like your the first in the hierarchy of needs. And if that need isn't met, then how are you supposed to focus on anything legal and going through such a complicated system?
And the stress that it puts on transition house workers too, right? And like
Hmm.
all the clients they're trying to find housing for in a province that severely lacks it. I could go on about that forever. But the other thing I'll say too is the really disappointing issue of the IPV tort. Everyone I know in BC was really excited about that. And then to have that happen was pretty devastating because there are a lot of clients that I have with really complex financial situations in the sense that you know, maybe their opposing party doesn't have a formal income because they are living off of a trust fund, for example. So how do they impute income onto an OP in court, for example, and then have, you know, set child support and spousal support, those sorts of things. So being able to prove other things to get them some sort of financial compensation to increase their likelihood of having stability, whether they're on their own or whether they're with children, for example, or other dependents that they might have. Yeah.
I just want to add with that intimate violence tort. So if people aren't familiar, in February 2022, a landmark trial decision in the case of Aluwila versus Aluwia. It happened in Ontario Superior Court, and the Justice Manhan ordered a husband to pay his former wife $150,000 in damages on account of the pattern of violent abuse he inflicted on his former wife during their 16-year marriage. So Justice Mandan created this tort. According to her, existing torts do not fully capture the cumulative harm associated with the pattern of coercion and control that lays at the heart of family violence cases and which creates the conditions of fear and helplessness. Sadly, this July 2023, Ontario recently had a decision where the appeal court declined to affirm the new tort. So that's kind of a bit of the background. So there was one, and now it hasn't been affirmed. So we'll see what happens with it.
Thanks
I'm
so much.
sure Naomi could also speak more to the torts as a lawyer than myself.
Thank you so much, Natalie. Yes, I will move over to Naomi, and Naomi, please feel free to speak about the tort, but I had a specific question for you. So in our scorecard, we do measure alternatives to law enforcement responses. So I was just wondering if you could go over what some of those alternatives might be and what is their significance to intimate partner violence victims.
Sorry, can you explain the alternative part of the question? I apologize.
Yeah, so no problem. So alternatives to law enforcement responses. So for example, we've heard of cases where social workers might be able to go out to an intimate partner violence case rather than law enforcement themselves, or mental health workers and things like that. So we are wondering if you know of any other alternative responses to law enforcement, or anything you're seeing in your own work across Canada. And if you could explain their significance to intimate partner violence victims.
Right. So this is a question like it presents like two difficulties here, right? Because you have a lot of victims who feel like they can't go to law enforcement, whether they're vulnerable or marginalized in multiple intersecting identities. And then also the law enforcement response to economic abuse is usually that it's a civil matter and to call the Canadian cyber tip reporting line for I don't know what the number is or what the proper title is. And that is that doesn't respond to anything. Sorry, my dog just came back from the dog walkers. Because I had to use it, right? I had to make appropriate reporting when my privacy was breached. And it's very, I just invite any advocate to just go through the process of reporting something and just to get an experience of it to see how it is lacking. Obviously, don't make fake reports, but if you if you are personally impacted, to just to go through all the steps. And then the alternatives, northern rural areas are very limited, but I generally find that there is some benefit to just getting an incident number from the law enforcement. So even if you don't want them to take any steps, you just want to create a record of the incident and make it clear that what you don't want them to do or what you do want them to do. So sometimes that can just help protect the rights of the victim later down the line if there's any civil proceeding launched in terms of the steps that she took to protect herself. And then other alternatives include connecting with nonprofit resources. I know that everybody's stretched across the country, but I generally find that building relationships with those organizations can also connect victims at least with some services. We also have to remember that some victims may be well versed in what is appropriate for them. So they may also come to you and say, look, I've tried everything and I'm at my wit's end and I don't want to receive. I know the nonprofit sector, this isn't like to speak negatively about them, but they have packages available sometimes that they give to victims. Sometimes those packages need to be tailored to victims who one, economic abuse victims, but also who have been through the system before and who are well versed in how it works through their own experiences. So just putting the agency back to the victim can be really empowering for them. And also just sitting down and working with them to help build sort of a plan of action with them can be really empowering for them, and just at least help them get a little bit of their power and then power back.
Amazing, thank you. And yes, absolutely right about giving victims and survivors their agency back by working with them. I think that's fantastic. There are a few questions coming up. I will ask your questions just at the end, but just to wrap up the formal panelist questions that we had, Samantha, you spoke to this a little bit. So Naomi, I'll ask you, are there areas in the scorecard categories or in the scorecard yourself that you feel that there is more work to be done? And I'll also ask for your impression about the Ontario and Alberta rankings as well. What did you think about those ratings?
Sorry, let me just open up the scorecard. Can you to me again? Sorry.
Yeah, so what areas in the scorecard do you feel that there is most work to be done? And it could be the scorecard itself, or it could just be what provinces and territories need to work on the most.
Again, it's the law enforcement stuff. I think that there needs to be more training and more insight into how this impacts them, because this is, again, I'm not trying to bash people doing important work or to draw negative light or attention to them. It's just to highlight, the gaps. We often see, as a criminal defense lawyer, so I see when I'm working in the north, I see a lot of individuals who are migrating to the north, but at the same time, there's also a lot of crime that comes from the south to the north. And a lot of that crime is based on economic, there's a sort of an economic value, if you will. So there's usually connected to human trafficking, guns, drugs. So there's usually some sort of economic exchange happening. So we have to start, I guess maybe this is also some feedback for us, is to start framing or to start providing information to law enforcement that frames it in language that they use, right? Because it is a crime to steal money. It is a crime to steal identities. It is a crime to access something, meaning property like a bank account, without permission and without authorization. And I think this is why it's also important to help support victims, to help get resources set up separately from whatever situation that they're in. So really communicating to banks, like going in there with them and, you know, sitting down with like as advocates and you know, getting that separate bank account set up. Because oftentimes, you know, when these separate bank accounts are set up, there's all sorts of checks and balances in the back end. And so those checks and balances include credit report checks. And that could be very limiting, especially in the economic abuse context, that, you know, you're just cut off right there. So there needs to be some sort of, I guess, education around that as well. In terms of the second part of the question, the difference between Ontario and Alberta. So I actually I practice across across Canada. So I've been seeing an increase, and I do a lot of online harassment work. So I advise usually women primarily on their rights in online harassment cases, and sort of what can we do to get to the heart of the matter. So sometimes they don't want to make a report. Sometimes they do want to make a report. Sometimes they just want to talk to somebody to just make sure that it's not in their head, right? That this is what they're experiencing. And sometimes that's important. So what I'm seeing is actually a trend in male counterparts bringing court applications to, obviously from our perspective, my perspective, abuse the court's process. So to try to silence them, to try to make them, you know, commit to things that they obviously shouldn't have to commit to in the context of the abuse that they have experienced. And that can be really hard because we also then need to leverage sort of the expert reports that need to support the client's claims, right, of economic abuse and whatnot. So there's a lot of change happening across the country, but I would say that one of the increases that I'm seeing is online harassment, and in the context of abuse, all sorts of abuse. So like, and then also in terms of the male counterparts bringing these court applications. I'm aware of it existing primarily in family law, but there's a lot of it coming in civil law. So filing like large claims against clients, so like in the $1 million range claims, or filing in Nova Scotia, they have a court process that's called the Cyber Act, the Cyber Bullying Act, and you can get a court order. And sometimes clients have exhausted all the resources. They've gone to the law enforcement, they've gone to whatever institution they need to go to, they've gone and made all the reports, and they literally, like, they're experiencing ongoing abuse and harassment, and they post about it on social media because it's not stopping, right? And then all of a sudden this court application starts, and so where do we find the balance here, right? So if somebody's not doing their job, and I hate to say it, but law enforcement needs to start investing in more resources into understanding the economic abuse context.
100%. Yeah, completely agree. And you touched on a little bit of what Samantha was saying about victims just being overwhelmed with the amount of court cases that their perpetrators are using against them. So like leveraging the legal system to silence them or coerce them into a settlement that they don't want to take. So I'll move the question over to you, Samantha. So what areas in the scorecard categories do you find that most work needs to be done? And I think you spoke a little bit about it, but would love to get some detail.
Yeah, I think I can kind of pivot and speak more to kind of what Naomi has also said too around the alternatives to law enforcement. For many of my clients, I largely work with clients who are outside the Lower Mainland. So for anyone who's not familiar with British Columbia, the Lower Mainland generally is made up of Vancouver and sort of the greater Vancouver area. So more densely populated, more of like an urban area. So largely I'm working with clients who are in smaller or rural or remote communities, or generally just underserved communities around the province, where responses to intimate partner violence are generally quite terrible. A lot of the time now, I'm finding, especially over the last 2 years, I'm helping clients not only with their family law file, but also with filing police complaints, whether that's due to the way they were mistreated in the interaction, or how, like, let's say, like physically or something like that, or just how generally they were dismissed by the officers responding to the situation. And then you've got my other very large number of clients who simply do not want to contact the police. And I know I'm not saying anything new here at all. But we do need some sort of alternative to this, because I have so many clients that are like, it's just not worth it to me. I have so many clients that don't even bother calling and making a report at all, even if it can help them with their family law file later, just by having those reports made, especially when it comes to figuring out parenting issues. Because, like, for example, I have clients who are going through family court right now, and we're trying to prove why the other party shouldn't have access to the children, or why there should be limited or supervised access. But then we're going off of just, for example, my client's affidavits, as opposed to, more substantive evidence that might be made up by something like a police report or something like that, or charges even, which again are far less likely. Yeah, and I think another frustrating thing, and I might be kind of going on a bit of a tangent here, but I have situations where clients have recordings of incidences that have happened, where other people have provided recordings of violence that has taken place. And this is physical violence, even just like with things that, types of violence that are viewed as less important in certain eyes in enforcement, where Crown won't pursue charges because video isn't evidence enough. If we can't even get something as like widely accepted as bad as physical abuse accepted in courts, economic abuse is just like a whole other issue, right? It's harder to see, people are less aware of it. And this is what kind of brings me to this thing that I've been really thinking about quite a bit, which is starting to talk about these sorts of things with younger people. I have clients in their 80s, 70s who don't know what any type of abuse is other than physical abuse. They have no language for it. They don't know that it's defined at all in legislation, for example. And so thinking about like what it means to teach younger kids, if we're talking about, health and career, a lot of people end up in relationships in their lives, talking about what it means to understand your finances, understand what it means to combine your finances with another person or multiple other people in relationships. What are the potential implications for you if you move in with someone? What are timelines that you need to be aware of when you're moving in with someone? What does it mean to share bank accounts? What does it mean to make sure everybody's in the room when you're signing off on things? Making sure other people know when you're signing off on things. Are lawyers checking what you're reading contracts before you're signing off on them? All those sorts of things. I know a lot of clients who sign off on, let's say like waiving a right to something regarding a bank account, and then they don't ever have to have permission asked of them in order for something to, be transferred or whatever that might be. So I know this isn't necessarily something that's addressed in the scorecard, but I'd be curious to see if there's anything out there, whether that's federally or even provincially or municipally, I don't know, around educating people around these issues to try and, get ahead of, these situations that people are so often finding themselves in. Sorry, that's a bit of a tangent.
No, that was great. And you brought up some really good points, especially around the education piece. We actually answered a question in the Q&A chat in regards to that. So someone, one of our participants asked if there was anything we had on education, because we have fact sheets for women on economic abuse for victims and survivors, and we have them for banks and financial institutions, and also for shelters and social services. And so they're asking if we had anything like that for, the rental or housing component. We don't currently, but we would love to. But just on that front, education amongst youth is really key and really important for prevention. And so for us, for CCFWE, we're doing our best on doing the education and awareness part. And that's where events like these come in, or our tools come in, but also our National Economic Abuse Awareness Campaign that is going to be happening in November. And that's the opportunity that we want to take to spread the word about economic abuse and play that part in prevention. With speaking to younger and younger people, we think that's really important, and we do hope to expand to that. But it's we're trying to do so on the national scale for now. But I absolutely love that, because you're right in that when like these kinds of conversations on economic abuse should start when people are really young, because that's when they get into relationships, and that's when they learn about what's okay or what's not okay in relationships. So to hit that early is key, because once you get used to a particular type of abuse early, then you're just going to always be putting up with it if you don't know that it's wrong. So it's a really, really key thing. I'm just there was something else that resonated with me in your response, Samantha, which was when it comes to law enforcement, and it was something that you were saying too, Naomi, is that a lot of clients sometimes are not even comfortable going to the police. And that's something that we saw not just with our consultations with victims and survivors, but in our study that we did in the Ottawa region on economic abuse, and our national study that Natalie also led, that social services found that victims didn't want to contact police. And also we found that as well within our Ottawa study, that victims and survivors didn't want to go to police, and especially even during COVID, because during lockdowns and things like that, clients were actually in the home with the perpetrator all the time. And usually when they went to work or anything like that, that's when a victim and survivor has a chance to call law enforcement, and they just couldn't do that. And some of them just don't have that trust. Some people in the chat have also been pointing to that RCMP, their RCMP doesn't know about economic abuse or heard about outreach programs. So the education component within law enforcement is absolutely key. I'm just going to go over a couple of questions in the chat that came up that were really, really important. So this one comes from Leah. Would you say that family law professionals, I'll open this up to everybody in the panel, and also Natalie. So would you say that family law professionals and others in the legal profession need more training to understand litigation abuse in relation to domestic abuse, and to include economic abuse? So I'll just let anybody who would like to respond, Naomi or Samantha or Natalie. So do you think lawyers and court systems need more education? I think we touched on it a little bit earlier.
So I don't practice family law,
Mhm.
but I actually am retained by legal counsel who do family law matters, because I do civil and criminal. And so a lot of the times I'm advising on like the claims made in family law, or whether there are intersecting criminal code allegations, and sort of how to protect any victims in that proceeding and sort of their identity. So I repeatedly and almost always say, get a sealing order, get a publication ban. And I wish that was more often sought for in family law proceedings. I know it's a really high threshold, but economic abuse, any kind of abuse, can be very alienating, isolating, and you kind of don't want it out there in the public record that, you know what, you were abused financially by your partner, and then that sort of puts like you in a weak position, right? That you're vulnerable. And so it could leave you a lot of open to a lot of judgment, and also any children who may be involved. So I always tell family law professionals who come to me and I say, well, did you get a publication ban and sealing order? And almost always they say no. And I say, well, get it. And there's specific provisions in family law proceedings and the rules that govern those proceedings that allow, the threshold is a lot lower in a civil proceeding. So if you get it there, and if the civil proceeding is launched elsewhere or a criminal law proceeding launched elsewhere, you may be able to get it and convince the proceedings elsewhere, because that court order doesn't, you can't violate that court order. So that's just the most simplest thing that I tell family law professionals. Even if your client didn't ask for it, just you have to give all the options to them, and they have to decide.
100%. Yeah, Samantha.
I think, I mean, I can't necessarily speak to what like the legal test is around being, you know, deemed a vexatious litigant. I think though it does appear to me in my experience that the threshold is quite high. And maybe even I'd go as far as to say too high. Of course, it's important that people are able to make applications to the court, especially when, you know, it pertains to children and access and those sorts of things. That being said, the sheer number of applications that some opposing parties will make, it is truly incredible, like that it's not being addressed in a more, I guess, enforceable way. I've been in court many, many times where a judge or a master has looked at the opposing party and said, you need to stop doing this, but it's not a formal order or anything like that. It'll just kind of be like a on the back of the hand kind of thing. On the record still, sure, but it doesn't have the same effect. It might be a bit embarrassing, but for a lot of opposing parties, being embarrassed is not going to stop them from the things that they're doing. I've also, you know, it can be complicated too, right? Because then some of the opposing parties in my files will, you know, say, oh, let's go to mediation. And then everybody has this idea that mediation is going to be the thing that's going to get them through the family law matter faster. Everything's going to be agreeable. Everybody's going to suddenly be, you know, willing to work with the other person, collaborative, and then they just end up wasting thousands and thousands of dollars in mediation, being treated terribly. And, you know, mediators are very limited in what they're able to do in those situations, unfortunately. And then we're back in the court process, and then they'll get another notice to mediate, and then they'll go back to mediation, and it draws things out forever. But again, it's just like another, in my view, another means of controlling someone with under the guise of like, look, we can get this sorted out outside of court. Or I even have some opposing parties that will say, I'll only cooperate if we do this outside of court. And then, you know, it's back and forth like that, just like the different tactics of abuse. And I would even argue that, especially when a client has a lawyer that they're paying for out of pocket, or that they have legal aid for, draining their hours, draining their retainers intentionally by making these applications, by sending a lot of really long emails. I see that too. And that's such a subtle way to do it, right? Because, you know, nobody's talking about their billable hours necessarily. People aren't advertising what they're dealing with in their family law file, often because they're told not to talk about it. And so, you know, I have opposing parties that will send these massive emails that like you're spending forever reading, multiple of them a week, sometimes multiple a day. Your lawyer's reading them, the paralegal at the office is reading them, all of these different factors that are contributing to either racking up the bill or draining their legal aid hours, which again, I think is a very subtle type of economic abuse that, you know, is par for the course in family law because it's expensive and files take forever. And that's the expectation. Yeah.
Thanks, Samantha, and thanks, Naomi. Those are all really devastating things to hear from, I think, for the client side. Just the amount of things that can be used against clients and victims to continue to use the legal system to abuse them further, and especially economically when they're already so strapped in their financial resources. pretty devastating. And I think Samantha and Naomi, your answers touch on something that, well, a question that we got in the chat about litigation or laws that are a little bit less detectable. It is in this way, like this invisible sort of way, where abusers are just trying to undermine the legal system by using it against clients and victims. We have a really other interesting question. So this was directed to Samantha, but I'll open it up to Naomi as well if you know anything about this. So they said that you were talking a little bit about the lack of harmonization in the legal system, so the various level of silos. And they're asking, how do we create both a division of powers, but also cohesion and harmonization between various orders of court?
Yeah, that's a really good question. I think about this often, especially Naomi, you might be able to speak to this in situations where I have files that are family law but are intersecting with criminal law. It is so common for my files to be intersecting with criminal law, and there is just such a severe lack of any communication between these different institutions, which can make it really, really challenging. Of course, everything I'm about to say as a suggestion is going to make it more work for court registries and for the courts more, or the courts generally. But I do think that it's so important that at the very least, we have access to different files that are in different levels of court, or that are in, like, let's say in like police records, for example. A huge barrier for my clients often is literally just getting to the court registry and accessing their court documents, especially in Supreme Court in BC. It costs money, it takes time, it's $1 a page to photocopy. It's like completely inaccessible for so many of my clients who are generally very, very low income. And so, for example, if, you know, we didn't have to go and try and get police records and then have to file them formally with the court and all those sorts of things, if that is just one thing that could be reduced, that would be incredibly helpful. If, for example, you know, a judge or a master in Supreme Court had access to a provincial court file, even just to see what the documents are, or even if they do have access to actually take the time to do that, to see and understand a bigger, fuller picture of what's going on, that would be incredible. And it would do a lot for a lot of my clients. For example, a lot of the time my clients will go to provincial court to file things like a protection order because it doesn't cost money and it's supposed to be a little bit more accessible for a self-represented litigant to access. Supreme Court, there are a lot more rules. The standards are, in terms of filing documents and those sorts of things, are a little bit higher. There's a little bit less leeway, generally speaking, in BC. So a lot of those things are happening in a different level of court, but that the Supreme Court judge might not have access, judge or master might not have access to, or might not take the time to access. So even if that was like a standard, that you had some level of awareness of what was happening in the other level of court, that would be a huge benefit to my clients, especially the ones that can't afford to do everything in Supreme Court, because filing one document is $200 alone. Yeah, I think that would really do a lot, especially when there's property division and then they're in Supreme Court for property, but every other issue is being dealt with in provincial. Yeah, just that like communication, even like bare minimum, knowing what's going on at different levels.
100% for sure. Naomi, did you have any thoughts?
So I think just as advocates, you just need to communicate with the client about like the realities about, you know, what different legal recourse and actions can and cannot do. So oftentimes I just tell the client, like, I ask the client, like, what is your end goal? What do you want? And you know, sometimes because of the nature of my work, some clients say, well, I want him fired from his job. And I say, okay, well, you're probably not going to get him fired from his job. And so let's work to sort of come up with other solutions, right? And then working with them to understand the different recourse and different systems. So like the family law proceedings versus criminal law proceedings versus civil proceedings. because I'm seeing a lot of applications come against my clients who are largely women, and professional women as well, in terms of online harassment and the financial abuse that they experience. I found great benefit to, so it's a love-hate relationship, right? So it's like they file a lawsuit in civil court and I say, listen, your matter is a family law matter. You do not belong here. And so it's sort of like, there's sort of some benefit to those silos because then it says, listen, you brought it in the wrong system, and your remedy is not hearing the remedies over there, and please stop harassing my client, if you will. So there can be a good and bad to both things, and it's just working with other advocates, trying to come up with creative solutions to difficult problems. And sometimes it's just a matter of saying, you've took the wrong pathway, and we're not going to entertain your claim.
Mm-hmm. Yeah, just another way that that women are largely prevented from accessing their legal resources. Thank you both for that. We have another question that came in our Q&A that I might ask Natalie Snow to answer for us. So the question is, do you think that there will be an increased awareness of economic abuse with the addition of coercive control to the Federal Divorce Act, despite coercive control not being a chargeable offense under the Canadian Criminal Code?
All right. So my thoughts on this, so I was actually recently approached by Justice to speak at a panelist. They're doing a bunch of consultations with experts across the country to see if if the government should criminalize coercive control. And I presented last week with other panelists. I'm very torn by this. Do I think that women's safety should be of the utmost importance? Yes. Do I, from my own research and where I study, is many people don't have a very good experience with the criminal justice system. When we talk about intersections of different identities, such as BIPOC and Indigenous, and then socioeconomic status, the justice system is not getting the necessary outcome that kind of is what is the ideal, or what is kind of like the idea presented. As Naomi mentioned it earlier, is that a lot of elements of economic abuse are already criminalized. And what is happening with that? So I fear that by criminalizing it, we're just adding, at this point, the social change that's needed in behaviors, in norms, are not going to happen just because the law has changed. I think, as Samantha mentioned too, we talk about education and awareness. I think that would be where the funding should go and how to prevent this, because we're seeing violence increase. Not just economic abuse, but violence, period, increasing every day in this country against women. And it's all illegal. It is illegal already, and the systems are not responding in the way that is best supporting ourselves, or women and women identifying. Last week, I was at an event, which I was part of, was Take Back the Night, which is a night to raise awareness for sexual violence, and taking part in Hamilton. And during the actual walk, a man came up and attacked Ileana, who works for SWAP, sex workers in Hamilton. They support sex workers, and anyways, she was attacked at the walk with a group of people. Something needs to change, because if somebody is that brazen in that attacking another person physically during a walk to prevent and raise awareness against violence, I don't think the laws, especially with the current, we've talked about the challenges with police, we've talked about the challenges with court, that's going to be the solution. I could go on about this for a while, but I'll stop and see if anybody else has any other comments on it. But I think that is maybe part of it, but there, with the caveat that there needs to be more spending and on education awareness, and not just for the general public, but people within this criminal justice system.
Yeah, actually, my master's research was focused on, it was around community drug checking and substance use stigma. But what I wanted to kind of contribute to that, Natalie, was like stigma is a huge part of this, right? There is so much stigma around talking about money. There's so much stigma about finances. And then when you add in that there's a family law issue going on, whether there's family violence, whether it's just a family law file in general, there's a lot of expectation that it's kept very private. I have had clients who have called the police and the police have responded and said, sorry, this is a private family matter. We're not getting involved. That alone is preventing people from communicating and talking to each other about it and sharing knowledge around what's going on. So I would just want to kind of, add to that focusing too on breaking down stigma around these things and making it something that people talk about more with each other. And whether it's on a broad national scale or even just like more of a micro scale, to get that knowledge sharing and stuff going. I think that's really huge. I'm seeing a lot more of it now, especially in communities around BC where there's organizations that are hosting groups for women and gender diverse folks to sit and just talk to each other. It's not therapy, it's just sharing their experiences and that knowledge sharing, which I think is contributing or beginning to contribute to reducing the stigma. But as long as we're, keeping things super private, people aren't going to know. It's uncomfortable to talk about. People don't like it, but it's, I think, one of the ways that it's going to help shift things because, changing laws, or enforcing them, it's, not going to be the answer, I don't think.
Yeah, only helps so much, right?
Yeah.
Sorry, Naomi, were you going to say something?
No, nothing to add other than what I've previously said. Everything here applies.
Yeah, and everyone here is just so right. There is a social stigma around it. It's something that's come up in our studies for economic abuse. It's something that even social services can have trouble with. Financial institution staff, when they know that there's a domestic violence aspect to something, they maybe want to avoid the topic or avoid the subject, but absolutely it should be put into the light more. And for that reason as well, that's why CCFW developed our economic abuse screening tool for social services to help social service staff be a little bit more comfortable with talking about finances and financial abuse and economic abuse, and figure out what the proper resources are. And we are expanding that screening tool for lawyers that our director of policy, Michaela Myers, is leading, and Natalie Snow is also assisting with as well. But hopefully that can expand the awareness of economic abuse within the legal system as well. It won't be the only thing that we need, but it's definitely what we hope is a step in the right direction. So things like comments that we're hearing from you guys today, like Samantha's saying that, checking the provincial court system and things like that, that's something that we could build into that tool as well. So thank you for that. I'm going to just double check to see if there are any more questions in the chat. There was just speaking on the stigma as well, something that we noticed was amongst newcomers and immigrants and refugees, there is also a huge cultural stigma about talking about finances in general. And so the women who come over are just severely under-resourced and undereducated about what their financial rights are. And someone in the chat asked a question in regards to immigrants as well. So they were asking, do newcomers and refugees have the same rights or protections as Canadians and permanent residents regarding economic abuse? to the best of your knowledge, Samantha, or Naomi, or Natalie? I'll open that question up to you guys.
Well, I don't practice immigration law, but because I have a large practice in Northern Ontario, and there's a lot of migration to Northern Ontario, encouraging settlement there. Their immigration issues do come up, so oftentimes the answer just generally is no, but it depends on the context and what's happening there. And so this is where banks need education around that as well. And police, like interaction with police can create vulnerability, like, reporting to police, then also then they may report to CBSA. So it creates this like extreme hyper vulnerability of not wanting to report, shaming and reporting, and then also the risk of reporting is that you get more reports that are out of your control.
For sure. Thanks for that, Naomi. Samantha, did you have any thoughts on that?
I'm not as well versed in immigration related stuff, so I will sit that one out.
All good, all good. Natalie, did you have anything to say? Is there anything that you know? If not, that's okay. We can move on to the next question and just work on wrapping up as well.
Let's move on to the next question.
Fantastic. So someone was speaking about something that the panelists were mentioning about how, just how the abusers are flooding the legal system. So they were saying that the opposing parties who flood the legal system and are increasing billable hours for victims and survivors, they're not doing this on their own. They're also working from a script that's given to them from their own legal team. They are asking how that group is held responsible or accountable, like lawyers like that, who might be encouraging those types of behaviors. Are there any ways that they're held accountable?
That's a really good question. Generally, again, this is just my like small bubble of experience. My worst opposing parties are the self-represented ones. I don't know where they're getting this information from. I don't know if it's Reddit or some other like men's rights activist kind of group. But the most challenging ones that I have are almost all self-reps. And they are, it's a weird little trend that we've noticed too, is that they go and buy law textbooks and then they bring their law textbooks with them to court. That's been interesting. I've seen that with multiple opposing parties, where they'll literally show up with like books and their binders. Yeah, anyways, that's a fun little tidbit. Yeah, so generally that's what I find. In my experience, one thing, and this is obviously I'm in a very privileged position to be able to do this because where I work, I know a lot of lawyers. And we have like a lot of connections with law firms around the Lower Mainland, especially, who will take files that are outside of this area. I try and find lawyers who know the opposing party's counsel, and who like have already established a good working relationship. That I find is very helpful, because then they both feel, in my experience, like they kind of owe it to each other to be like good officers of the court. Obviously, that's a lawyer's, mandate or whatever, part of their code of ethics or however they word that. But yeah, I find that is really helpful because then there's almost like this level of professional accountability to their co-counsel or the other lawyer on the file. So that's one thing that I've found has been a really helpful strategy. When I'm supporting a client who has counsel, in situations where they don't, sometimes, obviously I have no control over what counsel the opposing party has, but yeah, generally I find that it's a little bit easier to navigate when they have a lawyer that we're familiar with. Because a lot of it does sometimes come down to just like general respect, I've found. Of course, that's not always the case. And I do have some opposing parties who are definitely getting advised to drain hours. Yeah. And in those situations, often we'll send like an email or something. Again, that doesn't do much necessarily. Or if my client is represented, send an email just kind of setting expectations and saying that like we won't be responding to these sorts of emails. They need to come in a specific letter from the lawyer, for example, to kind of set the parameters and kind of like outline what the lawyer will and won't entertain.
Amazing. Yeah, thank you. I didn't know about, I don't think any of those things. The fact that abusers are coming to court with textbooks, probably just also to try and intimidate their victims or make other lawyers think that they, they can talk the talk. I hope that doesn't actually work, but the setting expectations thing is really excellent. Thanks. Naomi, go ahead.
Yeah, one strategy that I use, so I get a lot of harassment in my files as the lawyer often, and just pile from all sorts. Is often I just like if I get a long email, I say, I don't know what you're saying in your email. What do you want me to do? And then obviously I say it in a very professional manner, and obviously I review the email, but like honestly, like what is the point of your email? Like I don't know what you want me to do. Are you just like sending it to get stuff off your chest? And if that's the case, then it's not a proper letter to a lawyer, right? And it's not a proper use of your client's resources. So there's different pathways, and also just not responding to some letters because I know I'm right. Like take it up with the judge. Like I'm not going to respond, and a non-response is a response. So, and sometimes some things are sent to me to trigger a response, and I tell clients, I say, I'm showing this to you. I'm just letting you know that they probably want a response from me, but I'm not going to respond. We'll let the judge respond, and that will be the end of it. And obviously, those are situations where I'm very clearly in the right, and getting client instructions is important. So yeah, just reminding like the other side, like stop wasting my time, stop wasting your client's time. And if you have any issues with my position, take it up with the judge.
That's fantastic. Both amazing strategies to just let someone else deal with it, don't need to rack up billable hours with all this unnecessary items. Amazing. So with that, we are getting to the end of our event. So I just wanted to thank Samantha and Naomi both for being here and creating such an excellent discussion. I learned a lot myself. And I hope our participants learned quite a bit. I want to thank our participants who are so active. Thank you, Naomi. No problem. Yes, I want to thank our participants who are so active in this event, who are asking questions and putting in their comments and their own stories. We really appreciate that. It helps inform our own, what we see and what we'd like to talk about. And again, just on the point of raising awareness, I'll just repeat that we are having our National Economic Abuse Awareness campaign that is happening in November. For every week, we have a different theme. We'll have different events that we'll be posting on our website. So please follow us on social media. Please retweet, repost, because as the panelists have said, the awareness of economic abuse in Canada is severely lacking. And we hope to do something to change that. Please have a look at the scorecard that is up on our website. And thank you, Natalie, for creating that scorecard. And thank you to our background team. We have Nerida, we have our Executive Director and CEO, Macy, Patrick, our Director of Communications, and again, our funders, the Women and Gender Equality Canada, that funded the creation of the scorecard. So thank you again very much for coming, and we hope to see you again in November.
For October 18th for our release of the State of Economic Abuse presentation.
That one as well. Thank you, Natalie. Yes, October 18th is our next webinar. Thank you.
Thank you. Thanks, everybody.
Thank you.
I'm just going to run a